Thank you so much. It's really a great honour to have been invited to speak at this conference because it's an organisation which was founded by my step-grandfather, Sir Harry Gibbs, or as I knew him, Gramps. I knew he was an important person, but I didn't really understand why for most of the time that I knew him. My overriding memory of him is as a very gentle, kind and fair man who was really into books and fishing and made us get up at 4 a.m. to go fishing with him. But he made a real effort to make me feel welcome in his family. He passed away before I became really interested in law, which, if you look at the dates, you might know was actually while I was at law school and I was not interested for the first few years. But unfortunately, I later became quite interested in my legal studies when I studied administrative law, which from my biography you might have realised I have quite an interest in. So I'm not sure whether he would have agreed with the things that I have to say and with the views that I've developed through my research. But I do know that he would have relished discussing my ideas with me and would have done so thoughtfully and generously. While he was clearly far cleverer than almost everyone he would ever have met, I remember that he treated everyone and their views with the greatest of respect and with fairness. In discussions and debates, he never resorted to attacking the person when engaging with arguments. And I mention this because I think it's important in the middle of an election campaign to remember that we would all be better if we were all a little bit more like Gramps in that way. It's commonplace now for people to be threatened with violence or even death for simply expressing their views. And by people, I'd emphasise it mostly seems to be women. We've seen it during the current federal election campaign with Catherine Deves, and on the other side of politics a few years ago with Yasmin Abdel-Magid. And I think it's unacceptable, intellectually weak, and a threat to our democracy. And I'm sure that you would all agree that ours would be a better society if people were more like the founder of this one. And on that note, I'd like to speak today about my views on what the last few years have revealed about government power and accountability, and the lessons that we can take from the pandemic. So the COVID-19 pandemic revealed a great many things about our society, both negative and positive. It showed us the very worst of people, that we're really only one very small step from being in a real-life Mad Max movie, except that instead of petrol, we were fighting over toilet paper of all things. But it also showed us the best of people, our ability to come together to support one another and to put the collective good before our individual interests, as well as our creativity and adaptability. And for clarity, I don't include Microsoft Teams in the good column. One thing that the past 2 years have highlighted is the significant gaps in our system of government accountability. And I think this is something which should concern us all, irrespective of whether we happen to agree with the balance that our government struck in limiting our freedoms to protect public health. For it's fundamental to our democracy and our system of law that those exercising public power explain their decisions to those affected by them. Yet a large portion of the decisions made by federal and state governments were not properly justified. We were frequently told that health orders were made following health advice, most of which was not released. And the legislation empowering the making of health orders in some jurisdictions, including New South Wales and the Commonwealth, did not confer power on the Chief Health Officer to make those decisions, but quite properly on ministers. And this indicates that legislatures assumed the minister would take health advice, as well as other relevant matters into account in reaching their decisions and in balancing those factors. But we weren't told what those things were, what things had been considered in addition to health. And they clearly were, at least in New South Wales. Economic interests were clearly considered at various points, but we weren't told how the decisions were reached We were simply told to believe that governments were following health advice. The lack of accountability and transparency that we saw, I suggest, is a result of vulnerabilities in the mechanisms that we use in Australia to hold governments to account and to explain their actions. And I want to give 3 examples today. First, the oversight of delegated legislation. Second, the transparency of National Cabinet decisions. And third, briefly, the limited accountability over police discretion. And I'll also suggest some solutions and argue that accountability does not undermine the capacity of governments to respond powerfully, quickly and decisively to emergencies. The loss of accountability and transparency that we've seen over the last 2 years in particular are not necessary. So to start with delegated legislation, and I apologise, I have not been as kind to you at an early hour of a Saturday morning. I am, as Professor Toomey was. I'm going to jump right in and talk to you about delegated legislation. So most of the rules that were used to respond to the pandemic were set out in delegated legislation, which is ordinarily subject to parliamentary scrutiny via tabling and disallowance. However, a substantial portion of the COVID measures were not. At the federal level, Section 44 of the Legislation Act provides that delegated legislation may be exempted from disallowance through several means, and determinations made by the Commonwealth Health Minister under Section 477 subsection 1 of the Biosecurity Act in response to emergencies are not disallowable. Thus, the Commonwealth's travel bans, orders taking over hotels to quarantine returning travellers, rules making it illegal to price gouge when selling personal protective equipment, and regulations dealing with the use of data collected from the COVID tracing app, not that I think there was very much data collected from it in the end because it seemed rather useless, but among countless other orders were not scrutinised by Parliament. The Senate Standing Committee for the Scrutiny of Delegated Legislation was concerned enough about the lack of parliamentary oversight of much of the COVID regulations to establish an inquiry and a committee which kept a track of those instruments. At the end of 2020, the committee calculated that approximately 20% of the 249 pieces of delegated legislation made in response to COVID were exempt from disallowance. And I note that that committee has a government chair. And this is indicative of broader trends, both in the use of delegated legislation and in the proportion of it that's non-disallowable. Delegated legislation makes up about half of the law of the Commonwealth by volume. 31,132 legislative instruments were in force in June 2020, and the volume of delegated legislation is increasing. So too is the portion that is not disallowable, from 15% in 2014 to 20% in more recent years. And I think it's clear what the problem with the lack of parliamentary scrutiny of delegated law is. Our Constitution vests legislative power in the Parliament, and while the modern reality is that Parliament must and should delegate many legislative functions to the executive branch, Parliament remains constitutionally responsible for lawmaking. It may not abdicate its powers of legislation, in the words of Justice Evatt from the Dignan case. Parliament must oversee delegated law via its scrutiny processes to ensure that delegated laws are made within power, which includes being proportionate to achieving the objectives of the primary act. There may be a few limited circumstances in which non-disallowance is justifiable, such as bylaws made by elected bodies, but emergency is not one of those categories. Parliaments have shown a capacity to respond quickly and to adapt their procedures in emergencies. It's also very rare for parliamentary scrutiny to result in disallowance. Between 2010 and 2019, there were only 17 instruments disallowed. And there also tends to be a good deal of bipartisanship in emergencies, at least at the start. So there's simply no justification for exempting emergency delegated lawmaking from parliamentary scrutiny. And the position in the states was worse in some respects. Some, including New South Wales and Victoria, it wasn't even clear what the status of the health orders was, whether they were delegated legislation or administrative decisions. And while the Court of Appeal was no doubt correct to say that for the purposes of determining validity, it doesn't matter, and Justice Leeming was right to note that the distinction is artificial and problematic, it's nevertheless important from an accountability perspective because there are accountability consequences. Administrative decisions are properly overseen via review applications to the courts. Legislative decisions are appropriately overseen by Parliament. Court and tribunal processes are not suited to, or in many situations capable, of providing accountability for legislative decisions. And the health orders themselves were quite clearly largely legislative in nature. However, the relevant acts seem to assume that they were administrative. For instance, in New South Wales, in a badly worded subsection, an act seemed to provide for NCAT review. And the Minister took full advantage of this ambiguity in his submissions to NCAT in response to a challenge to the New South Wales orders late last year. The fuzziness of the language of the provision and the lack of clarity as to who was the proper body to scrutinise these orders meant that there was in fact limited oversight of them by any institution, and this could easily be fixed by a legislative amendment. However, another problem of my argument for increased parliamentary scrutiny was the fact that many parliaments simply did not sit for large portions of the last 2 years. For instance, the New South Wales Parliament didn't sit for most of the long lockdown. And this meant that they weren't scrutinising the orders themselves or able to call on ministers to justify the restrictions they imposed on us. So while premiers, chief health officers and ministers appeared at press conferences, this is not a substitute for oversight by our elected representatives. And there is absolutely no reason why the New South Wales Parliament could not sit in 2021. The rest of us had to suffer through endless Teams and Zoom meetings. The technology was well understood by then. Parliaments in other jurisdictions had navigated those challenges and continued to provide oversight. And I think it's unacceptable that ours did not. So moving on to my second example of the loss of accountability and transparency that the pandemic highlighted, National Cabinet and FOI. The federal government's adamance that National Cabinet documents won't be publicly released emphasises that there is a weakness in our laws. National Cabinet was initially heralded as one of the great successes of our response to COVID, as evidence of cooperation between the states and the Commonwealth, though that cooperation was short-lived. It was certainly, however, an effective forum for communication between premiers and the PM, but what it was not is a cabinet. It's an intergovernmental body, and as such, it's not held to account in the same way as cabinets. It's not responsible to a single parliament, but to 9 separate parliaments. And that is not to say, so the rationales for keeping its documents secret don't apply as they do to actual cabinets. And that's not to say that there aren't good reasons to hold, or that there might not be good reasons to keep some, perhaps even many, of its documents confidential, at least for some period. But they're not the same reasons that apply for the blanket exemption of cabinet documents from access to information laws. The cynical amongst us thought that the labelling of the body as a cabinet might be an attempt by the federal government to rely on the cabinet exemption to the Commonwealth FOI Act. And they were proven right when, after the AAT found that the National Cabinet is not a cabinet and that its documents are therefore not exempt from the FOI Act on that basis, the Prime Minister introduced a bill to amend the FOI Act to prevent the release of National Cabinet documents. However, the bill went much further and would have exempted the disclosure of a host of documents produced for other intergovernmental bodies as well. and there's no clear rationale for withholding public access to much of that information. And as with delegated legislation, these developments are not unique to the COVID emergency, but reflect a broader trend towards federal government secrecy over the last decade in particular. Ministers have refused routinely to comply with Senate orders for the production of documents claiming public interest immunity. For example, ministers refused to provide the health and economic data and information which formed the basis of its COVID response, despite public servants initially being willing to provide that information. The Senate Select Committee on COVID found that these claims were not adequately justified and reflect a pattern of conduct in which the government has willfully obstructed access to information that is crucial for the committee's inquiry. Ministers have also made blanket immunity claims over information about the robo-debt scheme, even after the litigation had concluded, without explaining in any way how the public interest would be damaged by the release of that information. They did the same with other information that might have embarrassed the government, including sports rorts. The fact that release of government information might be politically damaging and embarrassing for a government is not a justification to refuse to release it under FOI or to a democratically elected parliament. Without access to this information, we as voters are unable to understand and make judgments about the basis on which decisions have been made and public funds used. Other developments which support my claim of a decline in government transparency at the federal level include the stripping of funds from the Office of the Information Commissioner after an unsuccessful attempt to abolish it, the gross underfunding of other integrity and accountability agencies, including the National Audit Office, efforts to place strict controls on the advocacy activities of charities and not-for-profit organisations, secret prosecutions of whistleblowers, unlawful police raids on journalists' homes and offices in efforts to find the source of government leaks. A New York Times journalist in 2019 described Australia as the world's most secretive democracy. The problem this highlights is that government transparency very much depends on the willingness of the government of the day to be transparent. The executive branch has a lot of power to simply refuse to explain themselves, and often there's little anyone can or is prepared to do about it. There aren't independent bodies with strong enough powers who are willing to use them to provide an incentive or require secretive governments to be transparent, and there should be. For starters, the Senate should establish an independent arbitration process to deal with public interest immunity claims like that in New South Wales and be willing to enforce it. And the Information Commissioner should be fully funded and independent, as should other accountability institutions. The final accountability gap I want to speak to relates to police discretion. The health orders were largely enforced by police via fines. The orders were necessarily drafted and redrafted in haste, and this meant that there were often ambiguities in them and uncertainty as to what the rules were at any point in time. In addition, the rules contained a range of discretionary elements, such as deciding whether a person's excuse for leaving their home was reasonable. The result was that a great deal of discretionary power was in the hands of police, which again is not unusual. But studies and data show that there was a disproportionate impact on disadvantaged of communities in policing. Research by University of Wollongong academics shows that fines were used as an extra form of punishment for alleged criminal behaviour by suspected drug users, young people, people with mental health issues, and people in unstable housing. The same research shows that police were themselves often very unsure of the law due to its rate of change and took an overly restrictive approach to its interpretation, for instance, seeing exceptions as a fixed list rather than examples of reasonable excuses. Whether police get the law wrong or act inconsistently or disproportionately, there are few good options for challenging fines. There's no cheap, independent review mechanism. There are internal review processes, but they're extremely limited on the grounds on which fines can be challenged, and reviews rarely succeed. There's no avenue to argue that police exercised their discretion in a manner that was discriminatory, disproportionate or unfair. And the mechanisms that do exist may not be known or available to disadvantaged communities. The only other option for challenging an infringement notice is to go to court, which usually results in a much higher penalty as well as court fees if unsuccessful. Thus, there's a strong incentive to pay fines, even if they've been issued unlawfully or unfairly. Those who can afford to usually take this option, and those who can't often don't pay, which can have significant consequences, including an escalation in penalties, a far larger debt, garnished wages, and imprisonment. The limited review system that exists makes sense, given that fines are designed to be an efficient enforcement mechanism for minor non-violent offences and to save all parties and taxpayers from the cost of criminal proceedings. However, as the New South Wales Law Reform Commission observed, the system does not have the transparency normally associated with justice systems in democratic societies. Most people simply pay the penalty, only 1% go to court, so that guilt or innocence is rarely scrutinised. There are avenues for review, but they are limited. Further, the system is regulated by guidelines, some of which are public but others are not. A truly independent, quick fines review system would help address this gap. It should not be full-scale merits review by a tribunal, but an actually independent review on the papers. And it should have a broader remit than currently exists. Mostyn and Kinchin, the University of Wollongong academics, also recommended better training for police on what the law is, given that they're charged with enforcing it. I'm not sure whether very much can be done about certainty, about the certainty of the law in emergencies, where rules need to change rapidly to respond to evolving circumstances. But the rules themselves do need to be easily accessible to those who are governed by them. And for much of the last 2 years, it was difficult to find some of the state orders, particularly the Victorian ones. In fact, I happen to know of a leading constitutional law academic, not Professor Toomey, who misunderstood a rule change and got stuck in New South Wales. If one of our top constitutional law academics can't understand the law, what hope does the ordinary person have? None of the accountability issues that I've discussed today are unique to COVID or even to emergencies more broadly, and nor are they new. There are existing holes in our system of accountability and transparency over the executive. It's simply that the experience of the last 2 years brought them into the spotlight. What some of them highlight is that even in a country like ours, with a web of laws and systems designed to hold the executive to account, much still rests on government's willingness to comply and commitment to letting the public know why they're doing what they're doing. There are loopholes which can be exploited to evade accountability and transparency, and they can and should be fixed. Accountability might look different in an emergency, but it does not need to disappear. Thank you.